think I did not expect to speak for this long, but it's gone on for at least an hour and a half, and I think I have overstepped my time, but I hope I have been clear in my presentation, and I've kind of covered the questions that were at least put to me. What I will try and do is I'm opening the chat box right now, and I'm going to just scroll down the questions and see if there's anything that I would need to cover which I have not covered.
Yeah, Farid, really this was amazingly comprehensive. You put it across in very simple terms, and a lot for us to grasp and absorb. And obviously there were very major key aspects that you address, such as various definitions of nominee executor, whether probate or not, and ownership. So many of those you have already answered. And again, as you look at the chat box, I just wanted to tell the audience on the webinar that you are welcome, right, Farid, to contact any one of those three individuals, yourself as well as your associates.
I set out, there's one interesting question, and I'll, most of the question, Asmita, are yours, so I can address you separately.
No, I was forwarding from others, Farid.
Okay.
No, because I received them directly, so I forwarded them to you.
I thought those are your queries because they came with your name.
I have, no, I forwarded them from others. So
one interesting question which is asked by a couple of people is what happens if the executor does not file the accounts and the inventory within 6 months? Let me tell you is normally the courts in Mumbai at least don't really strictly follow this, but it's possible that if somebody has a grievance of not accepting you as an executor, if there's a complaint which is made, then the court might take that very seriously, because one of the conditions of a probate being issued to you is that you will file these accounts and this inventory, and the consequence of not doing so may result in the court removing you from this position as an executor. So although I've seen a couple of cases where a disgruntled person has, because he had objected and has lost in that objection, still tried to take out his anger by filing a complaint saying that the executor has not filed the accounts. The courts, I would suggest that if a will is challenged and if you know that there will be people who have grounds of complaints to make against you, please file your accounts periodically. You don't want to be before the court where you are questioned that you have not acted in the responsible way that an executor is required to act, and that's a condition of granting probate to you, that you will file these accounts periodically. So please follow these conditions, which are conditions for a probate when they are issued to an executor. Asmita, is there, should I take up?
Yeah, one just question came up, whether the executor can open, meaning to read out the will on his own.
Yes, so of course, yes, the executor or the person who has been entrusted with the will, of course, can fix a date and time where he can call all the legal heirs and all the people who he thinks should be involved when he is speaking and disclosing the will. In fact, he can also, there's absolutely no embargo. He should call for a meeting and he should read out the will. According to me, after he reads out the will, he should also give a copy of the will to each of the legal heirs so that they can, comprehend and digest every part of the will. In any event, they are entitled to it after the probate petition is filed. So in all fairness, when he's reading the will and saying that this is the last document left behind, he should do it in an open forum, and he should give copies of the wills to people who are the immediate family. members.
I see. Sorry, Farid. One question that has come up is that if, and I'm just going to read it out, if nothing is done for 5 years and only when property in question comes up for selling, then one of the heirs, potentially legatee, starts a process or questioning. Is that outside of the 3-year window?
So, see, what will happen, the process is like this. When a person passes away, the society will transfer the property in favor of the nominee. Like we have discussed, a nominee is only a trustee. If somebody wanted to object to that person being the nominee or that person selling the property or being entitled to that property, I'm assuming that when the sale is happening by the nominee who has been nominated as the nominee for the property. Now, if somebody is not accepting that, that person would have normally gone to the court and not waited for this person to apply for probate. So if somebody is objecting to either the nomination or his right to be a beneficiary under the will, he would have taken steps already. Now, assuming that that person has not taken steps, when this person wants, as a nominee, wants the property transferred in his name as a legatee, the person who has not normally objected to, he has a right of objecting to it. And he will create that kind of a pressure to say that if you don't give in to sharing that property or sharing the proceeds of that property with me, I'm going to ensure that probate is not granted and you're not going to be then entitled to sell the property. So that will be a pressure tactic that could be used at that point of time when a person applies. You can obviously say that, but the courts will take time to decide it. And that is why my suggestion is that you shouldn't wait. You should apply for probate immediately. And it will only save time because you don't want a situation where after a period of time, people with time, they start reacting and relations change differently. People who you are close to as family members, because parents are not alive, it's possible that the same relations may not remain, and a person who may not have objected to the will on the immediate passing away of your parent might say that after 5 years, if my relations are not good, why should I not object? I will object and I demand a piece of the share of the property. So the suggestion is please don't wait. A property in Bombay, a probate is absolutely required in the case of a Hindu, in case of a Parsi. Please don't delay it. At some point of time, it will be required. Please obtain it while relations are good, while things are fresh in your mind. The moment you delay it, you will come into all these kind of problems.
Then becomes a major nuisance value.
Yeah.
So then couple of questions, I'm going to try and just combine them. That is there a time period for opening the will from the passing of the testator? That's one question. And what if the family members during that set time somehow do not show up or become difficult and not attend that meeting? What would that do? And in that case, does the executor have a right to start distributing in accordance with the will?
So two things. One is you should wait for the funeral to take place of the deceased. Once all those last rites of the deceased are over, maybe for Hindus, I believe it's about a 13-day or a 10-day requirement. So once those processes are over, you should fix a meeting after that is over. And you should, then disclose what the will has been, left behind by the deceased and give copies. For those who have chosen not to attend the meeting, there are two possibilities that you could consider. You could send them a copy of the will, saying that we had fixed a meeting, we had requested you to attend, you have not attended, but the people who attended the meeting, copies of the will were given to them. So since you've not attended, we are distributing or giving you a copy of the will so that you become aware that this is what has been left behind. And then if it is property in Mumbai, Calcutta, Madras, or if it belongs to a Parsi or to a Hindu, then you have to then take immediate steps of filing for probate. The distribution of the property can only happen after the probate is obtained.
Okay.
So the distribution in respect of these religions where probate is mandatory cannot be done till the probate is obtained. In respect of Christians and Muslims, the properties can be distributed because there's no legal requirement of probate. So depending upon the religion being followed by a person, whether probate is mandatory or not, the distribution can happen only then.
Only after, and again, just to be sure, probate cannot be challenged, correct?
No,
Once
so
the
what
probate
happens
is certified.
So what happens is the first step of proving a will is to file a probate application. If somebody wants to contest the will, then that person will file a document which is called as a caveat. He will need to file that document after notice is issued by the court to all the legal heirs that this will has come before the court. The will is required to be proved because the executor has made an application. Anybody who wants to challenge the will, the court gives them 14 days time to challenge the will after the notice is issued. If somebody wants to object to the will or challenge the will, then that person has to file his objection in a document called as a caveat within 14 days. After the filing of the caveat, that person who has challenged the will has to set out the reasons why he has challenged the will. Now that is called as an affidavit in support of the caveat, and that has to be done within a period of 8 days from the date when the caveat is lodged. Once the caveat and the affidavit is filed before the court, the probate petition gets converted into a testamentary suit. And then in a testamentary suit, the court will decide whether the will is valid or is not valid, and will go into the nitty-gritties about the execution, whether it was signed by the deceased, whether it was attested by the witnesses, whether the deceased was of sound mind, whether all the compliances that the law requires has been followed in this case, and then we'll go into the objections raised by the other side and pass its order.
Thank you. And sorry, I think we'll just cover the last question. I thank you for your very extended time and patience. Someone has asked, what are the company securities? One of them, I think, was on the slide. The nominee is the owner or can receive. One of them was insurance policies and I guess company securities. So what would you call
company securities? Are normal shares and debentures that you subscribe to in a company. So these are normal shares and debentures. You're a shareholder, debenture holder. When you nominate somebody in respect of I use the word securities because anything concerning a company will be covered under nomination. So whether it is a share, whether it's a deposit, whether it's a debenture, a nominee becomes an absolute owner. In case of an insurance company, a nominee becomes an absolute owner. But in every other case, immobile property, government security, PPF, mutual funds, a nominee is only a trustee and he doesn't become an absolute owner.
I see. And also the cooperative society, that's often on people's minds. I think that is very clear, and I think we have covered pretty much all that was on the chat box, at least for now. And I know there's a great deal for every one of us to think through and apply our own specific conditions. And unless Prakash, do you have any concluding comments? But I, at least on my personal behalf, really, Farid, thank you so very much for incredibly clear, crisp, and how you managed to cover so many questions and so many different facets. So huge thanks to you, Unnati and Sneh from your JSA firm. And of course, the Citizens for Tomorrow, Prakash, Ruchika, and Nilima, of course, very, very appreciative of all the hard work. And Prakash, do you have any concluding comments, remarks, please?
Yeah, I just want to say, Farid, thank you very much. Had it not been for Asmita's problems, and had it not been for the recommendation of my son Aditya to contact Anish, we would never have met. Thank you very much. And you
Prakash, I believe everything happens for a reason, and I'm happy to share my thoughts and my knowledge with all of you, and it's been a pleasure.
And I really suggest all in the group, of course, to do reach out to Farid and the group. This will be on the recording is there. And again, right, to remind, the information is proprietary. So it's not to be shared casually with others, including in case some photographs of the slides have been taken. These are for our personal use, and any legal representation of sharing is not advised at all. And we must reach out to Farid and JSF firms if there are any specific questions.
So Farid, Sneh and Unnati, thank you very much for preparing this detailed presentation. I think that will save many people time to think and also money to pay fees. Fees might be reduced with certain lawyers.
Yeah. No, really, thanks so much. Time to get organized and put thoughts on paper. So again, Farid, not to go on, we have taken much too much of your time and that of others. So thanks so very much. Thank you all. Have a good evening. Stay well and stay safe.